Hello and welcome to our monthly Health Action webinar, Allowing Discrimination, Proposed Section 1557 Rules. My name is Justin Mendoza. I'm the Partnerships Manager here at Families USA, and I'm excited to introduce and bring to you all an expert panel to talk about the U.S. Department of Health and Human Services' new proposed rule that would severely weaken the Affordable Care Act's prohibitions against discrimination in health care. First, we have a couple of pieces of housekeeping. First of all, today's presentation is being recorded. The slides and the recording will be made available afterwards, and we will be taking questions in our chat box, which should be on the bottom left corner of your screen. As you get those questions in, we'll actually hold on to those and we'll answer those at the very end of the presentation after we hear from our 4 guest speakers. All right, so for today's agenda, we'll be starting out with an overview looking at the Section 1557 rules and the Affordable Care Act. We'll talk about how it affects LGBTQ protections. We'll look at implications for reproductive health care and talk through the impacts on limited English proficiency populations. And then in the end, we'll take those questions from you folks as you're tuning in. So, without further ado, I'll introduce our first speaker. First, we have Cheryl Fish-Parcham, our Director of Access Initiatives at Families USA. Cheryl, I'll hand it over to you.
Thanks. I'm going to start by giving you a very brief overview of what Section 1557 of the Affordable Care Act itself says, the regulations that are currently in place, how those proposed regulations would undermine protections to allow discrimination, and the regulations have been in place for a while and the proposed regulations are new. And I'll talk about why it is so important for consumers to comment. The other speakers will delve deeper into each of these topics as they explain what will happen for women, the LGBTQ community, and people with limited English proficiency. The law itself incorporates the Civil Rights Act, Title IX of Education Amendments, the Age Discrimination Act, and Section 504 of the Rehabilitation Act to say that health programs and facilities and activities funded by federal agencies or those administered under Title I of the Affordable Care Act can't exclude, deny benefits, or discriminate based on race, color, national origin, sex, age, or disability. That is in the language of the law itself. And to be more specific, the law applies to, quote, any health program or activity, any part of which is receiving federal financial assistance, including credits, subsidies, contracts of insurance, or under any program or activity that is administered by an executive agency or any entity established under this title. And this title is Title I of the Affordable Care Act, and that's the one that lays out protections in private insurance and establishes premium tax credits and exchanges. Rules detailing the requirements of 1557 were finalized by the Obama administration in May 2016, and it's those rules that are now in jeopardy. Those rules explain that you can't deny or limit care or set up a benefit design that would discriminate, that sex discrimination includes discrimination on the basis of gender identity, sexual orientation, and sex stereotyping, that people have to receive notice of their rights, and this includes notices for people with limited English proficiency, and notice to people with disabilities who might rely on auxiliary devices to communicate with their health plans. People with limited English and people with disabilities must have meaningful access to health programs and facilities. There's a general statement in the May 2016 rules that they don't apply if they violate statutory protections for religious freedom and conscience. But as other speakers will describe, this is an area where there's been litigation. Not only are there questions about what health care procedures a provider could object to based on conscience, but there are also questions about who they could entirely refuse to treat, and those are very scary conversations. The 2016 rule explains that people who have been discriminated against can file grievances with their health care program, complain through the HHS Office of Civil Rights, and the Office of Civil Rights actually has a web page where you can learn more about how it's acted in those cases in the past. You can look at their newsroom to find that out. And you can go to court to enforce your rights. So now let's talk about the proposed rules. The proposed rules would strip away many of these protections, and the proposed rules were published in the Federal Register June 14, 2019. CMS put out a fact sheet and an advanced copy of those rules in May, so you might have been hearing about them for a few weeks now. Some highlights of those proposed rules are that it eliminates some of the earlier definitions of covered entities and of what it means to be discriminated against based on the basis of sex, as other speakers will describe. They eliminate important language access requirements and notices about your rights. Health plans and facilities would no longer be required to have a written grievance procedure and compliance coordinator, so it would be harder to enforce your rights. The list of covered entities was narrowed so that many agencies that give grants, such as CDC and HRSA, would no longer be covered. And as Mara will explain, it eliminates the private right of action that allows people to go to court based on 1557. So it's really important to comment on these proposed rules. And I know you might be discouraged about the public comment process because you've seen a lot of public comments that didn't seem to result in a lot of change in rules in the past. But comments can lead an agency to modify or drop a harmful proposal. And even though this administration seems to have a poor record on that score, HHS must read and respond to public comments before finalizing a proposed rule. We've already seen with the public charge proposed rule that at a minimum, lots of public comments can slow the process of bad provisions becoming final. And a public record is essential if there's future litigation. So please comment by August 13th, and our other speakers will tell you more about areas of concern and where to find sample comments.
Thank you, Cheryl, for laying out the process, the basics, and the understanding of the rule. Next, we'll hear from Luke Athayde-Rizzaro, Policy Counsel at National Center for Transgender Equality. Luke's going to dive into and talk to us about how LGBTQ protections are at risk under this new rule. Luke.
Thank you so much, and thank you everybody for having me here today, and I'm excited to be here to talk to you all about Section 1557 and its importance for the LGBT community and kind of what is at risk right now. So to begin, I think it's important to kind of discuss, even beyond the 2016 rule, the really major impact that the Affordable Care Act had for the LGBT community. As you all, most of you know, Section 1557 was really the first time that sex discrimination was protected in healthcare at the federal level in such an expansive law that basically touched upon most aspects of healthcare in this country. And we have case law over the past 2 decades, including Supreme Court precedent in the case of sex stereotyping, that shows that sex discrimination protections like the one in Title IX and in Section 1557 and in Title VII does include protections based on discrimination, does include protections against discrimination based on gender identity and sexual orientation and sex stereotyping more broadly, right? So basically you are protected from discrimination from someone who's trying to discriminate against you because you don't conform to what their idea is of what a woman or a man should look and behave like. So because of this history of case law, we saw as soon as the Affordable Care Act went into effect, and really starting specifically in 2012, a big change in access to insurance coverage for the LGBT community. For transgender people in particular, even before the Affordable Care Act, access to insurance was extremely difficult because being transgender was considered to be a pre-existing condition. But then even when we could get insurance, it was very common for most health plans to have these really broad discriminatory exclusions that said that if a transgender person needed access to transition-related care, that insurance just would not cover it, and it didn't matter that it was medically necessary or that they were already covering similar procedures for people with other health conditions. So when 1557 comes into effect, we really see those exclusions start to go away, both from an enforcement from HHS at the federal level that since 2012 had started to send the message that 1557 did protect LGBT people from discrimination, but also from enforcement from state regulators and other state agencies. We saw a real shift in the insurance market on this. There was a study from Out to Enroll analyzing the marketplace plans from 2019, for example, that found that 94% of marketplace plans no longer, in the 38 states that participate in the federal exchange, no longer had these transgender exclusions. And next slide, please. So that is kind of the stage for when HHS issues these 2016 regulations. Those regulations were issued after many years of public consultations, and in 2016 they finally officially clarify, right, that LGBT people are covered by the protections of Section 1557, and it gives examples of what that type of discrimination can look like. So, for example, the regulations are clear that LGBT patients cannot be denied access to care, cannot be harassed or be given lesser care because of who they are, that transgender people should not be forced to have what is quite common to happen, but they should not be forced to have intrusive or unnecessary examinations, right, just because they are transgender, and that people should be treated in accordance with their gender identity, including if, for example, they are going to a hospital that has a sex-segregated space, they should be placed appropriately in accordance with their gender identity. And next slide, please. So the regulations also go quite, the 2016 rules, I mean, they also go quite deep. They speak a lot about the issue of insurance coverage, right, and about these exclusions that I was mentioning. So officially, right, the regulations clarify that Section 1557 prohibits insurance plans from maintaining these blanket and categorical exclusions for transition-related care. They say that if they are offering similar care, coverage for similar care, for example, hormone replacement therapy or hysterectomies or other types of procedures that transgender people might need, that they cannot limit that coverage just because someone needs that service because they're transgender. They also say that insurance cannot deny coverage for procedures that are typically coded as sex-specific or associated with one gender, like pap smear or prostate exams, and that they cannot, refuse to enroll people because they are transgender. And the HHS regulations are really based on these 2 decades of federal case law that I was mentioning in the beginning, and HHS really does a really good analysis of the case law that existed at that time, including case law from circuit courts that made it very clear that transgender people were protected under sex discrimination laws like 1557. So now going from this good stuff that happened in 2016 to the new proposed rule. The new proposed rule in big contrast, right, with the 2016 regulations. It is based on a single district court decision coming out of the Northern District of Texas, which many of you might be familiar with. That's Judge O'Connor's court that declared the entire ACA unconstitutional. That court issues a ruling in late 2016, in New Year's Eve actually, enjoining HHS from enforcing the parts of the 2016 rule that protected people from discrimination on the basis of gender identity and on the basis of termination of pregnancy. And HHS uses this rule, which really goes against the overwhelming majority of other precedent that we have at the federal level, to justify changing everything that existed in the 2016 rule, its protections for LGBT people. So in practice, the way that they did this is they erased all references to the Affordable Care Act's protections against discrimination on the basis of gender identity. They also erased all references on the 2016 rule to the Supreme Court precedent on sex stereotyping and what it means to be discriminated against because you don't conform to what someone believes a man or a woman is, and that includes discrimination based on sexual orientation. So all of that language is gone. And it also, and then it does this really bizarre thing. They try to say these are conforming amendments, so they don't really even justify why they are doing it. But they are trying to now, they're proposing to erase all reference to gender identity and sexual orientation in several other HHS regulations, and these are from CMS. And for folks that have seen the rule and you're wondering why this is not just an Office of Civil Rights rule, but it's also a CMS rule, is because of this specific portion. So they are trying to wipe out these rules that are longstanding. Some of them have been in place really since 2006. Most of them were issued way before the 2016 rule, and they are not related to 1557. They are related to Medicaid plans, to the marketplace plans, to qualified health plans, and to the program for all-inclusive care for the elderly. And they explicitly have non-discrimination clauses in the regulations that protect people from discrimination based on sexual orientation and gender identity, and all of those are also wiped out. Next slide, please. So in terms of, and I know I'm running out of time, so I'll just be quick. So in terms of the immediate practical effects of this proposed rule, so even though the rule doesn't change the Affordable Care Act and it does not change all of that case law history that continues to exist, that transgender people and LGBT people more broadly are protected, it is already so confusing and promoting discrimination, right? We know that transgender people, for example, try to often do not seek care when they are sick because of fear of discrimination, and so we're worried that people are already doing that in higher proportions than they were before. And we also know that this rule is already sending a message that whoever wants to discriminate against LGBT people in healthcare spaces is going to feel free to do so now, because HHS is essentially sending this message that they will not look into these cases. Next slide, please. And so I just want to kind of highlight in terms of a good news the immediate pushback that we had against this rule. We had some really great statements from the AMA, the APA, and over 30 other medical associations pushing back against this rule. We had several health plans put out statements in favor of LGBT protections and also pushing back against this effort by HHS. We also had a few insurance regulators put out very strong statements, and state governors, and through our Protect Trans Health campaign and through other common gathering campaigns from other LGBT groups, we already have over 20,000 individual comments that have been filed on this rule. And so how you can help, I think we're going to talk a little bit more about that with resources at the end, but obviously submitting federal comments on this. We have the Protect Trans Health campaign, which is at protecttranshealth.org, where you can direct folks to submit comments. And it's really important for you all to be able to talk to other stakeholders and asking them to speak out as well. The more people across the kind of movement that we're able to hear to, including across the healthcare industry, the more powerful this pushback will be. And of course, continue to support bills that will shore up protections, like the ones in the 2016 regs, like the Equality Act and HIA, and really helping educate your community and the folks that you serve about their rights in this moment is going to be especially important, since people are confused and we are very worried that they are going to avoid care or that they are not going to know that they're still protected under the law. Thank you so much.
Thank you, Luke, and thank you to the National Center for leading the work on this and really raising up the Protect Trans Health campaign. It's a lot of opportunities there for folks to hop in and for consumer advocates tuning in today to take action. Next, we have Shana Goodman, Director of Policy for Reproductive Health and Rights at the National Partnership for Women and Families. Shana, we'll pass it over to you.
Great. Thank you so much for the opportunity to be part of this conversation today. And apologies for my raspy voice. I'm on the tail end of a cold. So I wanted to share a little bit, and Cheryl and Luke provided really helpful context. So I wanted to dive in a little bit more specifically to the implications of the 1557 rule, specifically for reproductive health care. And I think one thing that's really important is to see this rule in its broader context. This regulation is yet another opportunity for the Trump administration to attack access to reproductive health care and to abortion care specifically. It comes on the heels of numerous other regulations, like the Title X gag rule, a proposed rule regarding Section 1303 of the Affordable Care Act about how insurers bill for the abortion-related portion of a premium payment, as well as changes in the notice of benefit and payment parameters for 2020, just to name a few, and not to mention the groundswell of other attacks on abortion access happening across the country. So this rule is really another log on the fire, if you will. And the clear intent of the rule is to single out abortion and send the message that abortion care is not health care, even though we know that, of course, abortion care and all reproductive health care is basic health care. As my co-presenters have already said, the healthcare rights law is a groundbreaking civil rights legislation, and when it first passed, it was the first broad federal prohibition on sex discrimination in healthcare that specifically mentioned and included prohibiting discrimination against patients who have had or might need an abortion, and as well as providing protection based on other reproductive health choices that someone may have made. So that piece is really critical and something we at the National Partnership, along with many allies, worked very hard to ensure was part of the regulations issued under the Obama administration. And that's the piece that this proposed rule is attempting to roll back. Again, singling out abortion care and claiming that it is not discrimination when a hospital or insurance company or doctor tries to interfere with your ability to make decisions about your body and your health. Next slide, please. So specifically, the proposed rule would allow women and pregnant people to be denied critical reproductive health care services when they need it most. People could not only be denied access to abortion care itself, but could also be denied any medical care or treatment or denied health care coverage for having previously had an abortion. For example, a provider could say, I'm not going to screen you for a mammogram or give you a mammogram screening because you had an abortion 10 years ago. We are also concerned that under the proposed rule, a pharmacy could refuse to fill a prescription for contraception or any other prescription that they see as related to or too close to contraception or abortion medication. People could also be denied prenatal care if the provider doesn't agree with the circumstances under which they became pregnant, for example, conceiving outside of marriage or as part of a same-sex couple. We also have a lot of concerns that someone experiencing an ectopic pregnancy or a miscarriage, for example, in those circumstances that a healthcare provider could deny them life-saving care if they think that the person is actually presenting because they've had an abortion. So as was mentioned previously, Title IX is part of how the regulatory scheme is constructed, and so this proposed rule accomplishes this denial of abortion care by incorporating Title IX's exemption on abortion services. It's a little strange to be transporting language from an educational context related to abortion care into a healthcare context, but that's how the administration has chosen to operationalize this rule. And I do want to add quickly that this last bullet about ectopic pregnancy or miscarriage is particularly concerning to us given the broader context where more and more states are moving to ban or criminalize abortion care. We know that generally speaking, abortion care is very safe, and the real truth or reality on the ground is that if and when, in the face of these bans, more people turn to self-managing their own abortions, they'll do so by taking abortion medication, which is incredibly safe, safer than Tylenol in many instances. We know that the reality means that some people might need to turn to more desperate or unsafe measures to end their pregnancy. And if they do that and they experience complications as a result, there's a real fear that they might not only risk being denied care and treatment when they present at a healthcare facility needing someone to help them manage those complications, but they could also risk being criminalized as a result of that. Again, if a provider thinks or suspects that they might have self-managed an abortion, and that's the quote-unquote real reason why they're presenting. So it's something we're really worried about and keeping a close eye on in the context of this rule specifically, but also just writ large. Next slide, please. I also want to take a second to note that the harms caused by this rule are intersecting, and we know that LGBTQ people also need basic reproductive health care, not just people that present or identify as straight cis women. Reproductive health care over and above things that are transition-related, services like gynecological exams, contraception, abortion, pregnancy or prenatal care, fertility care, the whole range of things that we think of as reproductive health care are, of course, things that LGBTQ people also access. And we know, as Luke sort of hinted at as well, that healthcare access in general is often fraught for LGBTQ people, but we know that this is especially true when they try to access reproductive health care services specifically. LGBTQ folks are met with a lot of stereotypes and discrimination about their bodies and about what kinds of reproductive health care they might need or want. So, of course, we're very concerned that if this proposed rule does go into effect, that LGBTQ people will experience really particular harms at the intersection of their identity and their ability to access reproductive health care specifically. Next slide, please. So I want to just dive a tiny bit deeper, I know this has been mentioned already, into the religious refusal or denial of care provision. And we are thinking about this in the reproductive health rights and justice community as really reinforcing the refusal of care rule that the administration finalized in early May. And that rule broadly expanded the category of healthcare entities, providers, and individuals that could claim a religious or moral exemption to providing care. And under that framework of that what's now final rule, we really see very few, if any, limits on what constitutes a religious or moral reason for denying somebody care. And we know that the way that this is going to play out is that the most common types of care that folks are going to be denied is transition-related care and reproductive health care, specifically abortion access and care. So we see this rule, this 1557 proposed rule, as kind of a backstop or a belt and suspenders approach, if you will, with that previous denial of care rule. So again, this rule, like the previous one, expands who counts as a healthcare entity to include insurance companies, and just broadly gives folks license to discriminate against patients. Next slide, please. So how can you help? Again, I know we're going to talk a little bit more about this, but I just want to say specifically that for folks who are not squarely focused on reproductive health rights or justice, or haven't previously included that in the portfolio of your work, it would be incredibly helpful for you all as you're submitting comments to include statements of opposition to the ways that this rule seeks to undermine access to abortion care and to reproductive health care. We need allies across the community speaking out with us and really lifting up and highlighting this proposed rule for what it is, which is, like, as I said at the beginning, yet another attempt by this administration to tell women and pregnant people what they can and can't do with their bodies. So we hope that you'll join us in speaking out specifically against those provisions in the proposed rule, as well as joining a week of action on social media that begins next week to help amplify specifically the reproductive health-related harms of the proposed rule. And you can follow us at the National Partnership and our colleagues at the National Women's Law Center, who are co-hosting the Repro Week of Action next week. Next slide. And here's my contact information. I know we're going to take some questions at the end, but if you have further questions or want to know more about how you can help lift up these harms, please feel free to reach out. Thank you so much.
Thank you, Shana, for giving us that overview and that presentation on these incredibly important pieces around reproductive health. And we'll be excited to chat more about the Week of Action at the end of the call as well. Great. So just as a quick reminder, folks, please continue to input questions that we'll bring to our expert panelists at the end of the call after we hear from our next panelist. And next we have Mara Youdelman, the managing attorney at the National Health Law Program, here to talk to us about this rule further, and particularly about limited English proficiency populations.
Great, thanks so much, and thanks families for inviting all of us and hosting the webinar. The next slide, please. So if you're not familiar with NHELP or the National Health Law Program, just very briefly, we turned 50 years old this year, and we work on access and quality for underserved individuals and families. We worked with a number of civil rights groups as this 1557 provision was moving through Congress as part of the Affordable Care Act, and us, along with everyone else who's presenting today and many, many others, have worked really hard on the implementation of this provision. Next slide. What I really want to clarify is where we are and why we're here. So Section 1557, or the Health Care Rights Law, is in a statute. It was passed by Congress. It was signed by the President. It is part of the law. What we're talking about is the Trump administration's changes to regulations. Regulations, as you may know, are developed by agencies. They have to go through what's called a formal notice and comment period, both when they're being developed and then if someone later wants to go and change them. So we've been talking about these 2016 regulations that were the product of a very long process, as Luke said, getting information from stakeholders, putting out a proposed rule, considering comments submitted for that proposed rule, finalizing the rule, and then having the rule effective. That final rule was in 2016, and we've been living with it for the last number of years until the Trump administration has decided to propose changes. So that is right now why we are in a new public comment process, is the administration has said we're going to make these changes. We all have an opportunity to weigh in before they can finalize changes and then go into effect. So as of now, just to be really clear, the statute, the law, still in existence. The administration cannot get rid of it. They can try to make these changes to the regulations. There are no changes that have been made right now. The current regulations stay in effect until a new rule is finalized and then becomes effective. And even at that point, if there are challenges in court to a new final rule, that new final rule's effective date may be delayed. So we are still, as I think Luke said, under the status quo, but I think it's really important to highlight that because nothing has changed with the statute itself, and nothing has yet changed with the regulations. Next slide. I want to talk a little bit more broadly too, because we've been talking about how the changes are going to impact transgender individuals, women. I'm going to talk a lot about limited English proficient, but I want to again sort of take the big picture view and really focus on the fact that an attack on the civil rights of one group or population is really an attack on the civil rights of all. And those of us who were involved in crafting 1557 really were focused on moving forward from where we were, which was having one civil rights law addressing race discrimination, language access, another civil rights law addressing disability discrimination, another civil rights law addressing sex discrimination that didn't come into health care. The purpose of 1557 was to bring this all together and say it doesn't matter whether you are discriminated on the basis of race or age or sex or disability, you should have the same rights and remedies. And that's what's under attack here. And why we're highlighting some of the specific changes for certain populations, really this proposal repeals broad swaths of the current regulations that go beyond some of the populations we're talking about, and also impacts that intersectionality that someone usually doesn't get discriminated on because of one aspect. They might be a person of color who's transgender and also could be limited English proficient. And you shouldn't be able to have a different right or a different ability to complain because of one or all of those. And you shouldn't have to bring complaints under 3 different laws. So one of the big things, and I'm going to start talking about the proposal now, and this applies to all aspects of the protected groups who are currently under the purview of 1557, is it limits the number of federal health programs subject to 1557. So under 2016, the current regulations, it says this provision of Section 1557 of the law applies to any health program or activity administered by HHS, and then also beyond HHS, any health program or activity administered by a federal agency. So we talk about Medicare, which is a federally administered program. We talk about CDC or NIH, which actually does a lot of its own research in addition to giving out grants. We talk about the Federal Employee Health Benefit Program, TRICARE, VA, etc. All of those were intended to be subject to these non-discrimination requirements. What the current administration is proposing is actually to roll that back and say it doesn't apply to any federally administered program. It only applies to federally administered programs that were established under Title I of the Affordable Care Act. What does that do in practice? It would limit 1557 to marketplaces, and it wouldn't apply to Medicare, to federal employee benefit programs, TRICARE, VA, etc. Next slide. Another way that they're trying to change the applicability is limit sort of the breadth of 1557. And again, one of our intents in creating 1557 was to go beyond the pre-existing civil rights laws and to build on them. Up until Section 1557, non-discrimination was tied to receipt of federal funds. And we were trying, again, to go beyond that to say it's federal funds, but it's also, are you a federally administered program, and are you a marketplace or a qualified health plan? Under the current regulations, any entity that's quote-unquote principally engaged in providing health care is subject to 1557. So for example, if you are a health insurance company and you provide some plans that get federal financial assistance, so let's say maybe it's a Medicaid plan or it's a marketplace plan, and you also offer non-federal financially assisted plans, so you offer an employer plan. Once federal dollars touch that insurer, all of the insurer's activities would be covered by 1557. And this again was an expansion of the pre-existing civil rights laws because now we're reaching into private insurance that hadn't previously been covered. And in my opinion and many others, there's no reason that you shouldn't be protected from discrimination because you're getting employer health insurance as opposed to marketplace insurance. What the current administration is trying to do and how they've redefined it with this proposal is to say, well actually if you're a health insurance company, you're not principally engaged in providing health care. And therefore, we're only going to subject 1557 to you to the aspects of your business that take federal funds. So if we go back to that insurer and they participate in Medicaid, then their Medicaid plans are subject to 1557. But their non-federally funded plans, their employer plans, their short-term limited duration plans, their non-marketplace plans would no longer be subject to 1557. So we've created this divide. Next slide. I'm going to talk now a little bit specifically about language access. And this is an issue, again, that we didn't expect to be in this proposed rule. Luke talked about sort of the basis for many of these changes, which was focusing on the fact that there was a lawsuit down in Texas where one judge decided that HHS should not have allowed protection from discrimination on the basis of gender identity and termination of pregnancy. That forms the whole basis for many of these changes. But as I said at the beginning, the administration has gone way beyond the decision by that one judge, which even at that point was not following most of the existing case law, but to make these major changes with regard to the applicability, with regard to language access, with regard to people with disabilities, etc. So one of the things that they tried to do is they added in some of these rollbacks on language access because it gives them a financial reason to make these changes to the rule as a whole. They're saying they're saving $3.1 billion or so by rolling back requirements to provide these taglines and to provide notices. So currently, again, under the regulations we have now, any covered entity has to put taglines. It's a really short statement. It's like something that says, attention, this notice is important. If you don't understand it, here's a number to call. And that's supposed to appear in the top 15 languages in the state on all significant communications. It's a way to give a heads up to someone who's limited English proficient who might be getting an English notice that they actually can get oral interpreting assistance or maybe be able to request a translated document. The administration has completely deleted any requirements for taglines. There may be some other requirements and other regulations, but as a whole, 1557, again, applied to such a broad swath of the healthcare arena, and now it wouldn't. Next slide. Another provision that the administration is completely rolling back and getting rid of is a requirement for notices. And I think that Cheryl mentioned this up front. But every covered entity was supposed to post in a public place and send with significant documents a notice that informed people that entity wouldn't discriminate, that it would provide language services for people with limited English proficiency, it would provide other communication or auxiliary aids and services for people with disabilities, how to request those services, where to go if you don't get them, how to file a complaint, and have a designated employee who would make sure that the entity was complying with 1557. All of that, again, completely gone. And the administration admits in this proposed rule that some of the cost savings are not just because entities don't have to print and mail these notices, but that people aren't going to be informed of their rights and aren't going to complain. Next slide, please. Additionally, there's some changes, and I don't have a slide on this, but I do want to mention that affect people with disabilities. In particular, the current regulations prohibit an insurer or a health plan from designing a benefit that might discriminate against certain individuals. This is called benefit design discrimination. What we saw early on, before we had regulations for implementing this provision, is some insurers were putting, for example, all of their HIV and AIDS medications, even the generic ones, in the most expensive tier of the pharmacy. What that does is dissuade a lot of people from enrolling in that health plan because they don't want to pay those high costs. So insurers were finding a way to design their benefits that might lead to discrimination. And it didn't have to be an HIV and AIDS drug. It happened with drugs for MS. It could happen in terms of also creating networks and things like that. And the current regulations prohibit benefit design discrimination. And again, this administration deletes those requirements, so now we've lost some significant protections for people with disabilities and chronic conditions. Finally, there's a number of changes to enforcement as well. So along with getting rid of the notice requirement, entities don't have to designate an employee responsible for ensuring compliance and investigating complaints. It deletes a provision recognizing that there's a private right of action, which means an individual doesn't have to just complain to the entity or file a complaint with the Office for Civil Rights, but actually that an individual can go directly to court. It limits remedies under pre-existing civil rights laws, and it sort of seeks to eliminate what we call disparate impact or intersectional claims. So again, the intent of 1557 as it was being drafted and as the regulations were being finalized is to say any right that's available under these pre-existing civil rights laws is now available to everyone. And what this administration is trying to now do is limit that and say, okay, if you're bringing a discrimination on the basis of language because you're limited English proficient, you only get the remedies that are available under Title VI. And that's a big problem because we've got some court cases that say, well, you know, if we say we're only giving our test in English, that's not directly discriminating against a Spanish speaker, but it's a disparate impact. It's an indirect application. And this administration is now trying to sort of use the pre-existing civil rights laws that we were trying to enhance and further limit individuals' rights and remedies. So next slide. I've attached some resources that NHELP has posted on our website. We also have a webinar coming up on July 9th with the Asian and Pacific Islander American Health Forum, where we're digging much deeper into just the language access provisions. So if you want a whole hour on that, we're happy to have you join us for that. And I'll turn it back to our friends at Families.
Excellent. Thank you, Mara, for diving in and giving us a taste of what will be covered on July 9th, it sounds like. Mara, before I open up to broader questions, we do have one question that's specifically for you. Just to clarify, when talking about 1557 and this new proposed rule, can you just rehash for us, where Medicare and Medicaid are subject to the rule and where they are not?
Sure. So this gets a little bit tricky. Let's start with Medicaid. So Medicaid is a joint federal program. The federal government sets out many of the requirements, but it's administered by state agencies. The state agencies are receiving federal financial assistance, so they would still be subject to everything we see in 1557. Medicaid providers also get federal financial assistance when they get paid by Medicaid, so they have to comply with Section 1557. Same thing with Medicaid managed care plans. They're getting the federal financial assistance to pay the Medicaid provider rates. Medicare is a little bit more complicated. Medicare is one of those federally administered programs. So under this proposal, and again it's not finalized, so it's only a draft, but under this proposal, what they would say is Medicare itself, when it's administered by CMS and people are deciding how to implement Medicare, is not subject to 1557. Why? Because under court cases and policy, federal agencies don't take federal financial assistance themselves because it's not an entity created under Title I of the Affordable Care Act. And this administration is trying to say federally administered programs and activities are not subject to 1557. That said, under an executive order, at least with regards to Title VI, Medicare would still be covered. Medicare Part B providers have historically actually been excluded from compliance with Title VI. Again, that's a long-standing, going back to how Medicare was originally established, and we could go into that in a whole other webinar. Email me if you want details. Part B providers are exempt and would be continue to exempt. Medicare Part C, Medicare Advantage plans, Part D, prescription drug plans, and Part A hospitals, again, should be subject to 1557 because they receive federal financial assistance by getting paid by the federal government. I hope that answers it.
Yeah, I think so. Thank you, Mara. That's incredibly helpful to clarify for folks. So next we were asked about resources that will be shared following the call, talking points, fact sheets, and other things. I would love, of course, we will follow up with resources that folks have sent us from this expert panel, but if any of you wanted to highlight one or two of your resources that might be particularly helpful to groups thinking about comments or about mobilizing their own memberships, it would be great to hear a sentence or two about those.
Hi, everyone. This is Luke. We're actually right in the middle of a Transgender Action Week. We've been working with partners, including folks who are speaking on this panel, about doing different action weeks focused on different themes and ways that people would be impacted by the rule. And NCT has put together a comment kit on this week alongside really nice social media graphs and language, etc. And I'll make sure that that link gets distributed to everybody.
Excellent. Sonia, maybe expanding on that with the Reproductive Health Week again?
Yes. This is Shana. I was just going to chime in to say that if you follow along the National Partnership on Twitter at NPWF, next week we'll be sharing out some resources and ways to get template comments or submit comments that are focused specifically on the reproductive health and rights component. So look for that to come next week.
And on the language access piece, we're working really closely with the Asian Pacific Islander American Health Forum, so we also expect to be able to share some template comments. And the Health Forum is putting together a microsite that will be able to drive comments in that focus on the language access provisions in addition to the other microsites I think that have been mentioned. And there'll be a Civil Rights Week of Action and a Language Access Week of Action in a couple of weeks to really sort of focus on those. And I do want to emphasize, I think Cheryl said this at the beginning, but others have said it well, even if you only focus on one aspect of these rules, we really think that it's important to at least mention the other issues, even if you don't go in depth. Use template comments, write in a paragraph about intersectionality or about why this impacts other populations and why you oppose those, even if that isn't your bread and butter issue. Again, I want to get back to this is an attack on the civil rights of all, but also part of submitting comments is building the administrative record because we do expect that there will be litigation on this after the administration finalizes a rule. And so it's really important to make sure that all of these issues are addressed in comments as broadly as possible.
Great. And Families USA has, at this point, just very general information that gives a broad overview of the regulations. We'll be adding links to other people's comments and template comments as they become available. So we'll try to help direct people to your great work. So thank you.
Great. And then a question related to that. Cheryl, when are comments due? Could you rehash that for us?
August 13th.
Excellent.
And you can comment. Regulations.gov is a place where you can file comments besides the template comments that are and microsites that are going around. If you want to address a different provision of the rule and just take a fresh look at it yourself, regulations.gov posts both a rule and a place where you can comment and look at other people's comments that have been submitted.
Excellent. Great. And then just as a process question for folks, when you're thinking after the submission of those comments, as Cheryl mentioned earlier, they do have to reply to these comments broadly. What kind of time frame should folks be thinking of to know what might come down the pike in terms of the final rule?
That's really hard to say because it will depend partly on the volume of comments that they receive. The more comments they receive, the slower they have to go because they do have to acknowledge and respond to those comments. Now, the response isn't to you. The response is in the preamble of the final rule. They explain what they thought of a particular comment. Excellent.
Thank you for clarifying that. And then we have one more question that's come in, which is when we're thinking about specifically LGBTQ people facing discrimination, does anyone here have stats that they can point to specifically as well around those populations accessing reproductive care?
Hi everyone, this is Luke. So there is unfortunately very little in data, hard data on kind of the difficulty for LGBT people to access reproductive care, at least as far as I'm aware, but I'd love to hear from others as well. In the U.S. Trans Survey, which my organization conducted, we had a couple of questions on access to reproductive health care, but those were more focused on access to these quote-unquote sex-specific preventative services that I mentioned, like pap smears and access to insurance coverage for these types of services. I'm not sure if anyone else who's on this webinar knows of specific research that on access to abortion care or other types of reproductive health care.
Yeah, I think Luke is right. Unfortunately, the data is pretty limited. I'm saying this off the top of my head without having double-checked to make sure that this is right, but the Guttmacher Institute might have some additional data beyond the good work that NCTE has done to collect some things. Planned Parenthood may have some additional data. I would have to double check on that, but yeah, it's unfortunately quite limited.
Okay. Great. Well, thank you all for joining and for diving in as experts on this topic and on these proposed rules. We'll be following up from this webinar with lots of materials and resources mentioned on the call, as well as some links that were sent to us beforehand. In the meantime, if you would like to get in touch with Families USA and dive in or connect with any of these speakers, if you didn't get contact information earlier, feel free to reach out to us at our info account here, head to the website, or at us on Twitter, and we'll get in touch and discuss these details. Thank you so much for tuning in, and we'll be following up soon.